Well, the theory is relatively straightforward. There are basically two elements. One, were hush money payments fraudulently recorded as legal fees and a business expense. That's the misdemeanor. The second element here is if the purpose of the concealment of the real reason for the payment was to make a campaign, an in-kind, if you will, campaign contribution, $130,000 to help Mr. Trump win in 2016, then that compounds the crime from a misdemeanor into a felony. Now, the purpose issue is one that's, you can say, is not open and shut case. Some argue he was trying to protect himself from embarrassment before his wife. His wife's former chief of staff said she knew about it well before the payment was made, so there was nothing to conceal. But that's an issue, but it's certainly not a far-out issue. One of the legal questions here is a matter of interpreting New York law, is that the campaign violation would be a federal offense, failing to report a contribution of that size. And it's a little bit unusual for a state criminal prohibition to incorporate as an element of the offense a violation of federal law. But I've had cases in New York where even on the civil side, that is the way in which the law has been interpreted. And so that's where we'll see. That's why we have juries.
Bruce,
this is not, however, an unprecedented. John Edwards, who was a Democrat, was prosecuted, for a payoff made to his mistress. He was acquitted on one count. The others were hung verdicts, and he never had a retrial. And also with regard to the idea that, this is normal reaction. Richard Nixon was about ready to be indicted before he got pardoned by President Ford. And despite Mr. Nixon's hostility to the press, he never resorted to the kind of violent language that we've seen from Mr. Trump. So this is not an ordinary human being reaction.